Um, Firstly, I'd like to say thank you very much for this kind invitation to be able to speak to you. It's a pleasure to be here, and also for PiSMoMo for thinking about organising such an event. My topic today is going to be about autonomous weapons systems and how they relate to international humanitarian law. This is the law that governs armed conflict and conduct in armed conflict. Why should we be concerned with this topic? The evolving nature of autonomous weapon and autonomous weapon systems, their unpredictability, and also the potential for them to remove moral and legal agency from humans, presents some challenges for the law, but also is a matter of concern for the public. So I'm going to begin by explaining what autonomous weapon or weapon systems are, and then explain how they relate to international humanitarian law, what the area of international humanitarian law is. I will highlight some of the ethical concerns and also legal responsibility concerns, and then I will conclude with some discussion about what is currently being deliberated at the UN before the group of governmental experts on lethal autonomous weapon systems. Firstly, it's important to state that there is no formal definition of what constitutes autonomous weapon systems. But in actual fact, the lack of a definition should not detract us from being concerned about this topic, or indeed trying to regulate such types of weapons. What we can say is that these types of weapons or weapon systems have certain characteristics which set them apart from other weapons and weapon systems currently in use. These characteristics relate to what are referred to as the critical functions of a weapon system. And those critical functions are acquiring, tracking, selecting, and attacking a target. A target could be an object, or it could be a human target. In any of those critical functions, the autonomous weapon or weapon system may have a level of autonomy. I'm going to explain what that is in a moment, but just think of it in terms of levels of autonomy. The more sophisticated types of these weapon systems may indeed have autonomy throughout all of the critical functions. And another aspect is that to some extent, they may completely remove human decision-making or human control. So let's take the first characteristic of autonomous weapon or autonomous weapon systems, and that's autonomy. What I mean here is that there is a level of independent decision-making within the machinery of the weapon or the weapon system that gives it a capability to act, and to act in those critical functions in a real-world military environment. And it won't require any form of external control, and it could be in one or all of those critical functions, the acquiring, tracking, selecting, and attacking a target. And remember that it could be an object, an inanimate object that's deemed to be a military target, or it could be a human target, a combatant. So that's the first feature or characteristic. The second is that these types of weapons are using new technologies, AI technologies, that broad category. So they are AI enabled. And this is artificial intelligence technologies to perform any or all of the critical functions that I've mentioned earlier on, that would otherwise be performed by human intelligence. So some examples of these technologies, from the very basic algorithms to machine learning, to deep learning, to robotics, and indeed neural networks. It could be a combination of these AI technologies. So it's an AI-enabled system. The final feature or characteristic is that because of this level of independent decision-making or autonomy that's enabled by the technology, it removes the human involvement. But more specifically, it limits or removes human control and decision-making. And these could be decision-making in relation to identifying a target, in relation to proceeding with attacking the target, a whole host of activities that take place in a decision-making process with the critical functions. Now, you will notice that I've referred to autonomous weapon systems. The GGE at the moment at the UN refers to lethal autonomous weapon systems. And I'll just briefly explain this difference, and I will mention it later on as well. The term lethal autonomous weapon systems has been adopted by the UN Group of Governmental Experts on Lethal Autonomous Weapon Systems, the UNGGE, since its inception in 2017. The longer title of the GGE is the following: to consider legal, ethical issues relating to emerging technologies in the area of laws. However, international humanitarian law doesn't require the feature of lethality for any weapon to be classified as such. There's no distinction made between a weapon that has a lethal effect, i.e. causes death, or non-lethal effects, such as injury, harm, damage, or destruction. What the rules of IHL are concerned with here are to capture the effects of the weapon, whether that effect may be to cause death, to cause injury, damage, or destruction. All of that relates to effects, and all of that is a subject matter for the law to regulate. So it really doesn't make sense to refer to lethality here, because the weapon or weapon system may or may not have that capability. In any case, we're concerned with the effects. So, for example, anti-materiel weapons, whilst they're not intended for human targets, may still cause excessive loss of civilian life, injury to civilians, or damage and destruction to objects. And these will be contrary to various rules of international humanitarian law, such as the principle of proportionality and feasible precaution. So lethality is not a relevant factor here. It's the use of force that we're concerned with that raises international humanitarian law and international legal obligations. So I will continue to refer to autonomous weapon systems to avoid any confusion and distortion of the law throughout this presentation. Okay, so let's move on to consider then what the law has to say in this area. And I refer in my paper to foundational principles. Since the drafting of the 4 1949 Geneva Conventions and the 2 1977 additional protocols to the Geneva Conventions, we have had many conflicts, and international and non-international conflicts. The Geneva Conventions relate to specific aspects of conduct in warfare, whether it's on land, whether it's at sea, prisoners of war, and civilian protection. So you will see there are specific conventions related to conduct in warfare, in hostilities, that require certain rules to be applied and adhered to. The 2 additional protocols, Protocol 1 regulates conduct in international armed conflicts, and Protocol 2 regulates conduct in non-international armed conflicts. Many of the provisions contained in both the Geneva Conventions and the protocols form part of what's referred to as customary international law. Now, what this essentially means is if a state hasn't signed and ratified any one of these treaties, some of the provisions contained in the treaties will already be elevated to the status of customary law, which means through state practice, that's habit and constant implementation, it's formed a body of law that will apply to all, whether they have signed and ratified a treaty or not. So what are the foundational principles of IHL, international humanitarian law? These foundational principles allude to values that are espoused in the law, protections that are afforded to categories of persons, and indeed the raison d'etre for the law. The first principle is the principle of distinction, and this is at the heart of international humanitarian law. It may sound rather contradictory to try and regulate something so hostile and so brutal as warfare. But actually, this is a remnant of centuries of exposure to the types of behavior and actions that take place in hostilities to try and limit the effects and the harms that can be caused. So the raison d'etre is limiting the harm, really. And the principle of distinction gets to the heart of this. The principle requires that there be distinction made between combatants and civilians, and military objectives and civilian objects. So there needs to be that distinction. The armed forces of warring parties must have that in their foresight. Populations of states in war are not the individuals or groups who should be subject to attack. They happen to be resident in that territory, but it's the state's decision to engage in warfare, and it's the state's decision to train and also authorize trained military personnel to conduct warfare during hostilities. So targeting attacks and attacks must only be carried out against combatants and military objectives. This foundational principle alludes to the law's harm-limiting effect. Separate civilians, separate innocents from exposure, and concentrate on what can be deemed to be legitimate military targets. It also affords protections to categories of persons and objects. So, for example, what are referred to as hors combat, these are injured or wounded combatants, will have certain protections. So will civilian populations and civilians who must not be the subject of attack. It is prohibited in law to be targeting or attacking civilian populations or individual civilians. So they are protected from attack. And this will apply whether it's an international armed conflict or a non-international armed conflict. So protection from attack is afforded to civilian objects as well. These objects are places of worship, places, critical infrastructure that is important for survival of a population, that's critical to the survival, and schools and hospitals. The second principle, that's a foundational principle of IHL, is the principle of proportionality. And this really gets to also the value of trying to limit harm. And one way that's achieved is military personnel in their operations and their actions must have this assessment in mind, i.e., the anticipated advantage to be gained from undertaking a military attack must be proportionate to the incidental civilian injuries or damage or destruction. Now that's the formulation. Let me unpack that a little bit. I stated earlier on that civilians and the civilian populations should not be the subject of attack. Indeed, it's prohibited to target and attack them. However, in warfare, of course, in terms of the practicalities and the conduct, there is acceptance that there may be unfortunate incidental harm that's caused through an attack. Note the word incidental. It's not the primary objective because of the rule of prohibition, but by attacking a legitimate military objective, it may cause some incidental harm to others, to civilians, to objects. If that is the case, military personnel must undertake the proportionality assessment, which is to weigh up, if the attack is to proceed, how extensive and what kind of incidental harm is likely to be caused. Because that assessment may determine that it's excessive, it's not proportionate, and therefore the attack should not proceed. And that is part of the rules of engagement for military personnel that derives from international humanitarian law. The third foundational principle is this principle of preventing superfluous injury or unnecessary suffering. And this is also closely aligned with that value in the law of limiting harm. It provides a direct link to weapons and weapons law under IHL, and indeed the types of weapons that are used, because it's not just any and every weapon that can be used in warfare. Some are deemed to be too egregious and too brutal in their effects to be allowed in the theatre of operation. So, for example, Article 35, Paragraph 2 of Additional Protocol 1 specifically states that, I quote, "It is prohibited to employ weapons, projectiles, and material and methods of warfare of a nature to cause superfluous injury or unnecessary suffering." These terms, superfluous injury or unnecessary suffering, referred to here, relate to the effect on combatants who may sustain or be exposed to such effects. Even in the context of hostilities, the law is seeking to contain excesses, which may lead to egregious injuries or suffering of combatants. Now, this is a remnant of the pre-1949 wars and indeed regulations of types of weapons dating back to the 19th century onwards. And I refer in my paper in the footnote 12, to some examples of those regulations. Okay, so we've got the sort of setting here of the foundational principles. And trying to bring it back to how these relate to AWS, I want to, at this point, identify some specific challenges here. And the first one is in relation to the level of autonomy that an autonomous weapon or an autonomous weapon system may have. The level of autonomy of the AWS will determine whether it is fully autonomous in all or some of the critical functions without human input or intervention, and whether it operates partially autonomously with human involvement. So that's the first challenging area. The second challenging area is in relation to human legal responsibility. Human legal responsibility needs to be attributed to the decision to use the AWS in the first place, as well as its actual use. If we look at the rules of IHL, these are rules that are predicated on humans, on the humans, whether as individuals or a collective of individuals represented within a state. And what I mean by that is, it's humans who will be reading, interpreting, applying, and implementing the laws. It's not a machine, it's a human that is doing that. And because of that, humans have obligations under IHL. With the introduction of AI and autonomous systems into the military context, military weaponry, weapons and weapon systems using these technologies, we will have potential self-executing functionality of these systems that they'll be able to perform on their own tasks and actions without human involvement. Now, should things go wrong, such as attacks on civilians or civilian objects, it will prove difficult to attribute legal responsibility to a human, unless there is human involvement, and that can clearly be identified, human control, and I will discuss this later on, or certain decisions only remain with the human. Final specific challenge just here at this point, after looking at the IHL principles, is the unpredictability of dynamic learning systems. Dynamic autonomous learning systems use advanced types of machine learning, deep learning, neural networks, to enable continuous learning from their own actions without human input or direction. But such systems create what we refer to as black boxes or black box scenarios, where humans cannot access or understand what the system is doing and why it's doing it. This creates a huge void for assurance that the foundational principles of IHL are being implemented and adhered to. If we don't understand what the system is doing, why it's doing it, we cannot explain, we therefore cannot assess whether it's complying with IHL rules. Now, with all of that in mind, I think there are clear ethical concerns with the development and introduction of these types of systems, whether it's a weapon or a weapon system that's autonomous. I have in my previous works written quite a lot about this because I believe that there's an ethical dimension and also legal dimension. Let's start off with exploring some of these ethical concerns here. If we are considering the use of AWS, then clearly in the military context, there's a potential for it to affect the right to life and indeed human dignity, using these in that context. Because of that, this reaches out to ethical concerns for how these systems are designed if they are deployed. Regarding the AWS characteristic of having the limited or no human control or decision-making, the question is not if we can, but if we should remove meaningful human control from the decision to kill, injure, or harm another human being. So in this instance, although we know the law covers human targets as well as objects, inanimate objects, the ethical concerns here really relate to that human targeting, because that impinges upon life and that impinges upon human dignity. And this idea of not whether we can, but whether we should, we know that technologies can be developed by human beings to be so sophisticated and so advanced. So it's not that capability, but it's whether we should be developing these and whether we should be deploying them. That is an ethical question. It's not about the system's technical capability or how advanced engineering or computer scientists are. We know that's there, but it's actually a much more profound question of the ethics behind it. So, as I believe, there's a fundamental ethical question of whether decision-making on the use of force, and more specifically on matters of life and death, should be retained by humans or taken by machines, regardless of the latter's technical capability in terms of algorithms or sensors. Beyond the technical capability concerns of AWS, there are legal and ethical constraints. Issues such as predictability, reliability, or explainability of this system raises more questions in terms not only of compliance with the law, but whether that's actually where we want to be heading as a human race. And I think that ethical perspective should guide states in their approach to, for example, retain human agency, control, and intent where it relates to decisions of force, to ensure that there is state responsibility, individual responsibility, and accountability, to uphold what's referred to as the Martins Clause in international humanitarian law. This is a very interesting clause because it's really the ethical heart of the law. And it came about from the 19th century as a kind of a mop-up provision. And what I mean by that is its wording tries to capture those areas that the law may have missed out or maybe hasn't developed yet. And it simply says, in those circumstances or cases where there is no law, then we must come back to the dictates of public conscience. And that's very loaded because that clearly relates to ethical considerations. What are dictates of public conscience? That may change over time, over decades, over exposure to different types of wars. Nevertheless, it's rooted in ethics and ethical considerations. So that is an important entry point for ethical considerations in terms of the law. I have also referred to in my writings, you'll see at the bottom, this phrase of the human essence of warfare. The human essence of warfare and human moral and legal agency. Now, what do I mean by this? The human essence of warfare identifies that there are individuals who are concerned with conducting hostilities, and attached to that will be certain responsibilities and accountability. And therefore, there is a lot at stake, and therefore actions and behaviours should not be taken lightly, particularly in this very specialised context of using force in hostilities. Because of the involvement of humans, there's more attachment to concern about assessing that behaviours are ethical, that they're legal, and therefore there is this human moral and legal agency. If you remove this from the equation of what takes place in hostilities and you introduce machine decision-making, there is no conscience there. There is no sense of assessing for feeling shame or guilt or feeling obliged to engage in a certain manner to apply the rules and adhere to the rules. It's simply a system that's based on algorithms. That does not satisfy the human essence of warfare, and how, because it's such a heavy area with regulation, but also a lot at stake, it does require humans to make those difficult decisions. That proportionality assessment, for example, that can be a very difficult decision. Nevertheless, because there's so much at stake, it means that it falls on human judgment, human experience and human judgment, and not simply an algorithm, a calculation to make that assessment. From the ethical considerations and concerns of autonomous weapon systems, I think we lead into concerns about particular aspects of the law in relation to these weapons. Let's assume that autonomous weapon systems are developed and deployed as weapons that are not prohibited under international humanitarian law, i.e., they would not breach the foundational principles of IHL, and therefore they would not be required to be prohibited. Even in that case, there would still be an ongoing obligation to ensure compliance with IHL and those principles. So you may design and develop an autonomous weapons system that appears to be in the prototyping phase, adhering to the principle of distinction, adhering to the principle of proportionality, adhering to the principle of preventing superfluous injury or unnecessary suffering. However, when you put it into deployment phase, when it's operationalized, you discover that there are problems. You discover that actually it's not able to target specifically or very well, and it's becoming indiscriminate. At that phase, you have made a legal discovery, and the obligation would require that that weapon system be removed from operation. This is what I mean about ongoing obligation to ensure compliance with IHL. It's not a static thing to simply say, we're designing a system that is compliant with X, Y, and Z principles. It's the operation of that system which will need to be assessed, ongoing assessment to ensure compliance, and indeed post-deployment as well. So that's one thing. A weapon may not be prohibited, but its use or form of deployment in the conduct of hostilities may be contrary to IHL. And this is what I mean in the slide where I say it's not just the decision to use autonomous weapons system or an autonomous weapons. It's the actual use that the law is concerned with as well. So it's one thing to say, we are developing and we are going to use this weapon in this theatre of operation. The law is concerned with that, but the law is also concerned with, okay, how do you actually use that? How is it actually deployed? And is it compliant with the law? So constant monitoring and review is required by humans to demonstrate that the weapon or weapon system can be used for the purpose that it is intended and the manner in which it is intended to be used and is in compliance with IHL. And of course, related to that will be attribution of legal responsibility to a human. I mentioned earlier on about the weapon, choosing the weapon, and this relates to an aspect of the law referred to as command responsibility. I will mention that later on as well. Here, it's the commander's decision of choice of weapon that the law is concerned with. A commander who chooses to use an AWS will engage command responsibility, that choice. Why was that choice made? Why was that choice made in that particular theatre of operation? What are the consequences of that choice? And indeed, is there compliance with IHL? So that is an example of attributing legal responsibility, a specific type of responsibility to a human, namely command responsibility of the commander. Under IHL, states also have an obligation to conduct legal reviews of new weapon or weapon systems, means and method of warfare, to determine that the new weapon or weapon system or means and method of warfare is compliant with IHL, but also international law in general. And that is part of the provision that relates to Article 36 of Additional Protocol 1. The formulation of this legal obligation of a weapons review is extensive. It covers different stages of a weapon or weapon system development and operationalization. So the life cycle. That life cycle relates to, I quote, the study, development, acquisition, and adoption stages. Clearly, we are dealing with new weapons when we look at AWS, whether it's a weapon or a weapon system. It could be argued it's a new means of warfare as well. If that is the case, states that are trying to use these weapons or indeed develop these weapons will have to undertake legal review. And that legal review will determine whether the weapon or weapon system, means or method of warfare is compliant with the law as it stands. That's at the very beginning, when there's design, there's development, the prototyping phase, the testing phase, actual deployment, and then post-deployment. You will see this is a very extensive obligation that states have. One thing about this obligation, it exists in international law, but how it is implemented nationally is rather opaque. There is no obligation for states to reveal their national review process or how they have undertaken the review process. And indeed, some states would argue that there are sensitivities, national security sensitivities, commercially sensitive information, which should not be divulged to the international community at large, or indeed certain states. But what I can say to you is there may be friendly states who do indeed share their different findings of reviews. The problem is we can't get under the bonnet, as it were, to see what each state is doing. We know there is this obligation, but we don't know how they are implementing this and to what extent they are truly considering how there is compliance with IHL. Therein lies the problem. And at the GG, there has been discussion of good practices of sharing reviews, good practices of providing examples. These have been some discussions, but some states are quite guarded in this area. And it must also be said that some states do not implement this obligation at all at the national level. There is no review that takes place. So that indeed would be worrying if these types of systems are being introduced into the battlefield, into the war zone, and there has been no review taking place as to whether they comply with the law. Okay, so let's now move on to the final section. I want to discuss a little bit about the UNGG process, what I have discovered, and some of the issues that have come up currently, the September 2025 session. What's being discussed? What are the issues? So just to start off, to give you some context here, the UNGG on laws operates under the auspices of the 1980 Convention on Certain Conventional Weapons. This is an international treaty, and it's been ratified by 128 states parties, and it essentially regulates conduct in warfare and either prohibits or restricts use of certain types of weapons. In December 2016, I participated in the drafting committees of the 5th Review Conference of the UNCCW, which at that point was considering whether to specialize or have a specialized group specifically on autonomous weapon systems. At the time, the UN Secretary General gave a welcome statement to the conference, noting that lethal autonomous weapon systems are, I quote, increasingly challenging for humanity with serious ramifications for international law. He commended the high contracting parties of the CCW for raising the challenge by establishing the group of governmental experts and said, quote, a welcome step to consider how the international community can take a proactive approach to this critical issue. The GG, which has been meeting since 2017, is composed of state representatives, military experts, lawyers, academics, civil partnership organizations, and UN agencies. So there is a breadth and depth of expertise in this forum, and I think it makes it entirely the appropriate forum to be deliberating this topic, but also to be trying to reach an understanding on setting some rules around these weapons and weapon systems. Now, an important result from this process, if we think that it's been going since 2017, an important outcome so far to date has been the 2019 guiding principles. It's a culmination of those early years of deliberations, and I must say, long and arduous deliberation sessions going on to very early hours of the morning, which produced a set of principles. And these were agreed by consensus by the states parties and were indeed affirmed at the GGE and adopted in September 2019. And you'll see in my paper the reference to the official document that contains these. Now, the set of 11 guiding principles range from initially reaffirming that international humanitarian law applies to these types of weapons, autonomous weapons or autonomous weapon systems. Whatever the state of the law, whatever exists at the moment in terms of rules and the principles, they will apply to these new types of weapons and weapon systems. So that's a positive sign, and that's a good sign. The second guiding principle, Principle B, refers to human responsibility for decisions on the use of weapon systems must be retained since accountability cannot be transferred to machines. There is early acceptance in this principle of the ethical concern for removing human control in decision-making and leaving that to systems or machines. That principle reaffirms the human is at the center and human responsibility must be maintained and cannot be delegated or transferred to machines. Principle C refers to human-machine interaction. I'm going to leave that to a little bit later on because I want to discuss this in relation to human control. Can be a little bit deceptive, that. And then if I just quickly move on to Principle E, it reaffirms the obligation for legal weapons reviews. There is mention in Principle F of concerns about cybersecurity, Principle G of a risk assessment that needs to take place. Principle J, some states were concerned that the development of these technologies should not be hampered by regulation. So it states the CCW should not hamper progress in or access to peaceful uses of intelligent autonomous systems. And finally, in Principle K, that the CCW offers the appropriate framework for discussing this matter. Now, it's interesting to note, those are the 2019 guiding principles, how far we have come, how far they have been reflected in subsequent work of the GGE, and in particular, the current draft, which I will refer to as the GGE draft text. Let me take the first issue here, and that's this terminology of lethal autonomous weapon systems. I mentioned earlier on that I have concerns about the use of lethal in this context. It is problematic. Under IHL, there's no requirement for lethality of a weapon for it to be classified or designated as such. And actually, it's irrelevant for the purposes of IHL, whether the weapon is lethal or not. It is the nature and the effect of the weapon or weapon system that is capable of causing injury, death, damage, or destruction that IHL regulates. I think it's misguided to continue to refer to lethal autonomous weapon systems. It creates ambiguity and misalignment with IHL. It's far better to refer to these simply as autonomous weapon or autonomous weapon system. If we truly want to reflect the effects of these systems, perhaps we can say autonomous weapon or autonomous weapon system that is capable of causing either injury to or death of persons or damage to or destruction of objects. Now, how did we get to the stage of having lethal, indeed in the mandate of the GGE, and this phraseology being constantly referred to? And it's proving to be a bit of a safety blanket for some state parties. Initially, back in 2016, there was limited understanding of what autonomous weapon systems were, what they were capable of doing, and there was concern about fatality, these systems causing fatality, and therefore ethical considerations there. So certain states wanted to refer to lethality of the weapon system. But our understanding of the capability of these systems has evolved, and we know they have potential effects beyond lethality. They can be causing injury and harm, not necessarily fatality. They can also be causing damage or destruction. So I think it's far more accurate and compliant and aligned with IHL to simply be referring to autonomous weapon or autonomous weapon system, and perhaps alluding to those different types of effects. The second issue here that I want to consider in terms of what the GGE is discussing is human control. Now, at the moment at the GGE, the text is containing the following phrase: context-appropriate human judgment and control. You may well wonder, what does it mean to say context-appropriate? What's human judgment? What's human control? If we take context-appropriate, whether it's in relation to human control or human judgment, we're referring to elements of space, time, target, and weapon system itself. What type of a terrain is the weapon being deployed in? Is it land, sea, air? Is it a built environment? Is it a mixed environment? Is it a forest? What is the time sensitivity for such a deployment? Is there a set time period? Is it on a loitering mission? Is it a matter of split-second decision-making where there's more urgency? And what type of a target is it being deployed against? Is it a military objective, an object, or is it a human combatant? These will have bearing. As for human control and human judgment, an example of human control is that area of law relating to command responsibility. The choice of weapon is a responsibility of a commander. The choice of weapon that is employed comes under human control that a commander decides on the methods and means of attack. If a commander orders employment of a weapon in the knowledge that it is unpredictable or unreliable in terms of discriminating against combatants and civilians, this would amount to a failure to discharge the obligation to prevent breaches of IHL. That's quite serious. The second example of human control, again relating to the commander, is the use of that weapon. It's the commander's responsibility to ensure that their subordinates are using the weapon in compliance with IHL. So whether that relates to training, whether that relates to restricting who or what can use the types of weapons, the commander will have responsibility in that regard. And a final aspect of the command responsibility, which illustrates human control, is prior to attack. The commander has an obligation to take feasible precautions. So these are some examples of human control. Now, in the 2019 guiding principles, you will see that principle B that refers to human responsibility. That is a reflection of an understanding of the human being in the loop, that there must be some human oversight, supervision, control, or responsibility. So there needs to be positive obligations in areas that the law is silent on. For example, unpredictability of AWS, the non-transferability of responsibility, or systems not to operate in environments on their own without some sort of human control. I mentioned human-machine interaction was referred to in the guiding principles earlier on. This is quite confusing because it's being used interchangeably with human control, and the two are separate. It's not the same thing. human-machine interaction is a form of human involvement with the system, not an example of human control. If we look at human-machine interaction scenarios, we may be able to elicit where it would require human control. But we can't replace human-machine interaction as if it represents human control. And as for human control itself, it will be relevant throughout the life cycle of the weapon system. So some examples of human control. Is there an ability of a human to intervene in the system, to stop what it is doing, to abort or suspend an attack? Is there an ability to deactivate the system? Is there an understanding of what the system is doing, how it's doing it, when it's doing it? Is there an understanding of that decision-making process? And can all of those be explained? The other aspect here that I want to touch upon is unpredictability. I mentioned this earlier on, that these types of systems, there is an element of unpredictability. When the AWS are designed and operate at a high level of autonomy, the underlying technology used to enable that could be a dynamic learning system, a sort of sophisticated machine learning technique that enables the system to learn from its own behavior and actions without external human input or intervention. Now, that can demonstrate a high level of independence in performance, but that can quickly be incomprehensible to humans. If we cannot understand what the system is doing, we cannot explain, we cannot then link to see whether it's complying with the law, and it's suggestive that there is loss of human control. So this is quite crucial in terms of how the rules will try and cover this element of unpredictability. And indeed, another aspect, this is something I mentioned at the GGE in September, is reliability. What does that mean to say that a system is reliable? Can it perform and undertake specific tasks according to what is expected that can be relied upon? In engineering terms, we have a term here, what reliability means. I quote, the probability of correct functioning to a specified life, e.g. measured in time or cycles of operations at a given level of confidence. In legal terms, it means that the weapon's critical functions relating to targeting, attack, authorization, and weapon effect should be compliant with IHL. A weapon could fail to meet IHL standards and requirements due to inadequate technical specification or a design flaw not identified at the testing phase. I'm going to wrap up now with just the final 2 points. My apologies, I'm running a little bit over, but if you'll indulge me to just conclude on these. Identification as a critical function. This has proved quite important for the Republic of Korea, particularly in the September GGE deliberations. Why? Because currently in the GGE draft text, in terms of those critical functions I mentioned earlier on, a weapon or weapon system, acquiring, tracking, selecting, and attacking a target, the representation of those critical functions is as follows. Select and engage a target. That is it at the moment. And states such as the Republic of Korea would like identification to be in there as a critical function. And I think that is quite right, because identifying a military objective or a combatant, it's a legitimate target, is a crucial stage. Everything else follows from that, and it precedes the selection stage. Some states may subsume identification in selection, but it's not a given, particularly with the types of technologies that we're dealing with now. The technology could be isolated to identify the target, and another type of technology could be used for selecting, or indeed we could have a combination of human machine interaction, as it were. So I see it as there are three different ways of identifying, of the identification critical function. One could be that a human identifies a legitimate target, straightforward. Another could be that it's an advanced machine learning system that's identifying the target, or it could be a combination of human-machine identification of the target. In any case, we need representation of that critical function. We cannot assume that it's in selection. The types of technologies that are involved, it's critical to represent that so that there can be regulation of what is happening, what the system is doing, and whether it's compliant with IHL. Finally, quite late on in the September GGE deliberations, this word functional came up, was raised. And some delegations wanted to use this word functional as the characteristic of what an autonomous weapon or weapon system is. And this is what they have proposed. I quote as the text: "A lethal autonomous weapon system can be characterized as a functional combination of one or more weapons and technological components." Now, to me, that is creating even more ambiguity. It's not creating a specific characteristic of the type of technology or indeed the type of these systems. It's just a very general word. The inclusion of the word functional narrows down the scope of inclusion of the types of weapon or weapon systems we are dealing with that could be subject to regulation. Indeed, this word has no basis in weapons law. It's not a requirement for a weapon or weapon system to be classified under AHL. It's also not a technical term. And importantly, it's contrary to the legal review obligation, that weapons review obligation in Article 36. Why? Because the legal weapons review obligation in Article 36 states the following: "In the study, development, acquisition, or adoption of a new weapon or weapon system, means or method of warfare, a high contracting party is under an obligation to determine whether its employment would, in some or all circumstances, be prohibited by its protocol or by any other rule of international law applicable to high contracting parties." The emphasis here is the study, development, acquisition, and adoption. We cannot simply wait for a weapon or weapon system to be functional, to be operationalized, for the law to be engaged. The law is engaged much earlier on, at the design, development stage, the study of these weapons. And therefore, this word functional would not cover that aspect. I'll just conclude by saying these challenges and concerns, I think, reflect the need for some parameters to be set around the discussions of autonomous weapon systems at the GGE, their development and their deployment, so that human control, agency, and responsibility are maintained. In terms of any regulatory instrument, I think it's important that we consider a combination of prohibitions, restrictions, and positive legal obligations.